started in the matter of Commission Recovery Ltd, Marks Clerk LLP and
Mr. Leslie, we're very keen to hear in the course of your submissions what the benefit of all this is going to be, bearing in mind the evidence about book building and so on, as a matter of discretion, if you get home on the, if you like, the points of substance. I don't want you to take you out of your course, but it's important, I think, that you know you've got to deal with that before 12:15.
Oh, I'm very grateful for the indications. Certainly it's part of my plan to deal with that point.
Yeah. You're going to have to speak up a bit.
I'm sorry.
You have this advocate's habit of dropping the voice at the end of sentences, which, particularly when we often compete with noise in this court.
I'm grateful. What I propose to do is first to address one point from yesterday afternoon, and then set out my brief plan for my submissions this morning.
You've got 3 more introductory submissions we're expecting.
That's correct. What I propose to do is to address, to advance one submission now, and the other 2 I shall weave into my plan, my further submission.
Okay, lovely.
So the submission I intend to deal with now is this. It concerns the position of Bambach Europe. Now, the point that is taken against me by my learned friend is that Bambach Europe's claim arises in the most attenuated possible factual context. But more crudely, he appeared to suggest that Bambach Europe comprises the worst possible set of facts for this type of claim. Now, in that respect, we adopt respectfully the observations of my Lord Justice Snowden. In a sense, Bambach Europe's individual case illustrates our core proposition that we do not need any particular facts to succeed. All we need to do is to establish that the relevant duties we require arise out of the standard terms of business. And in
that's not quite true. You need 3 facts. You need the relevant duties, you need an introduction of some kind, and you need a secret commission.
And just addressing those 3 facts, we say that we need the standard terms of business for the duty. We say the introduction is identified in the standard terms of business, and I'll take the court to those standard terms. And then as to payment, the payment of the commission is a matter of objective fact that defines the class. So that's why we say, in fact, all I need, we suggest...
Sorry, can you say that again? I don't think I got it.
The payment of a relevant commission is firstly a matter of objective fact, whether a payment was made. And secondly, it is one of the defining characteristics of the class.
But if you're wrong, and Mr. Mitchell is right, that it's a defence to your claim that you were introduced, or you made the decision, perhaps, you were introduced by Australia and you made the decision to instruct CPA independently of the referral, or that you knew from other sources, let's say, I don't know whether it is actually alleged, whether you knew independently of the commission, but let's just take that first one. If you're wrong, and that's included in the issues for determination on a representative basis, why should all the other members of your putative class lose as well?
Well, we say one has to be clear about the common issue and the res judicata that will arise. The common issue is as to the duties arising out of the standard terms of business.
So if your issues, and we need to look at what the issues are, I think more on a more granular level, if the issues are tightly defined at stage 1 to exclude the questions of introduction from another source, or consent, or limitation, or any of the other things that might be properly characterised as defences, then you say that's enough for a representative proceeding, but it will only get you to, as it were, a stage one determination of the common issues, and then there'll have to be a reassessment of Mr. Machel's desire to bring his tied hand from behind his back and have a go at that stage. Is that the way you see this working?
Well, that's not the way we see it working.
Right.
And it may be that the best way to answer that is by reference to the terms of business themselves. But we say it goes a long way. They go a long way beyond simply setting up, as it were, an architecture where a referral might be made. They comprise a number of features, including a selection and presentation, an express...
Including what?
A selection and presentation, and an express recommendation. We'd say also an implied recommendation on the authorities, because a selection and presentation comports and gives rise to an implied representation. And then there is also a grant of authority.
But I think with respect, what we're not doing here is you're putting your case to us, saying this is what I want to argue. You may be right, you may be wrong, but surely the point at this stage is to identify with precision the issue on which you may be right or may be wrong that can appropriately be tried under 19.8. You must assume against yourself that you're not right on this argument, because we're not going to decide it, but you must assume that the issue can be defined in a way that doesn't just create chaos or is uncertain. That's the question. So just being told what your case is, for me, speaking for myself, doesn't actually help me so much as actually looking at the issue that you think can be tried on a representative basis.
We'd respectfully agree. And what we suggest is that the focus should be, exactly as my Lord suggests, on the definition of the common issue.
What is the common issue?
The common issue, and perhaps if I might now turn up the list of trial issues, because it's the most convenient way to see what those how those issues are defined. That's tab 45.
Well, I'm looking at something with two columns called issues with 14 pages. Is that the document?
That's the document prepared by the appellants. If I might take the court to tab 45 at page 487 of the supplemental bundle.
It would be wonderful if I had a tab 45, but I have got up to tab 41, and in the first part of the supplemental bundle, I've got 10 tabs. So what page is it in the bundle?
So it's page 487.
Right, I don't think I've got that, unfortunately.
Are the issues in the right-hand column of Mr. Machel's list accurate? Do they accurately set out the issues on tab 45?
That's correct. If that's a convenient place for the court to take them. One sees it at 14 on the right-hand column. It's not quite the right-hand column. It's the column before the furthest right-hand column.
I've got 487 now. It's there somewhere. It's just that the tabs are completely inaccurate and the bundle is badly prepared, which is unusual. It is. Right, I've got 487, so we can have it either way. Never ever prepare supplemental bundles in two parts, ever, because two parts means that the page numbering does not coincide with the actual numbering of the bundle. Thank you. Just for future reference. For those of us that proceed electronically.
Just taking then the definition of those issues at page 487, the critical duties are those set out at 14 and 15. And they are in the nature of, they would potentially give rise to declarations as to the duties that arise out of the standard terms of business. Now, what we say is significant in the context of a secret commission claim is that once the duty is established, mere payment triggers liability. And what's critical, and we'll go to this in Wood, but it's well established, issues of inducement or reliance or causation are all presumed.
That's well established. But as I understood Mr. Mitchell, he characterised the duty as a duty to give disinterested advice, which is wording you find in Wood and some of the other cases and so on. And he said, but look at the facts of Bambach Europe. We didn't give any advice because you'd already instructed CPA before we were retained. So that's the battle line, is it not?
Well, we say with respect to my learned friend, it's a slight recasting of Wood. Language of disinterested advice is used in Wood, but it's in the context of the provision of information or advice or a recommendation. All of those things
Yes,
are included.
but as my lord said, I don't think we're going to decide who's right on that question. What we need to decide is whether there's something which is suitable to go forward as a common issue. And I think what you're saying is that your common issue is it enough just to point to the terms of business, or as Mr. Mitchell would say, do you have to look at what actually Marks and Clerk were asked to do?
Yes, and we say it is sufficient for us to point to the duty arising on the terms of business.
But why then do you have all these other? I mean, you pointed to 14 and 15 as the issues for determination, but then you've got 18 and 19 and 20, which seem to engage the whole of the gamut of arguments about whether the particular position of Bambach Europe, arising from the way in which it was actually introduced, is different. I mean, I don't at the moment understand how, for example, 18 and 19 are common issues in the same way as you say 14 and 15 are. 14 and 15 seem to be very common to anybody who signed the standard terms of business. But when you start looking at 18 and 19, it brings in all Mr. Mitchell's arguments about the particular position of Bambach Europe, don't they?
Well, what we suggest is that, and it may be that, as it were, in the way that the case is pleaded, there is an individual claim of Bambach Europe and a generic representative claim. These issues are taken from the trial issues, and the question is, can we extract common issues? Those are issues going forward to the main trial. Those ones we propose to be decided against a common, or in a common factual context.
But at the moment, as I understand it, Mr. Justice Knowles thinks that he's going to be deciding all these issues, that is, running up to 32. Is this right? On a representative basis? Or have I misunderstood? Well, where's the order that says? Because the order that you showed us says basically the issues that will be determined on a representative basis, subject perhaps to some tweak at a later stage, are going to be all these issues. And at the moment, you don't have to look further than 18A, where you've got at the end of 18A, the wording is in relation to the renewals of the IP rights of Bambach Europe and or each class member. I mean, how's that going to be done on a representative basis? You know, this is...
Well, but perhaps the way to address that is to take it as there are exactly as my lord says, there are two stages to the analysis, but both of them can be determined at this trial. We say at a representative trial on a representative basis. The starting point is to identify the duty. Once the duty arises, then the question is, if the duty is established, do these further matters flow? Essentially, is liability triggered? And at issues 23 and 24, the court is asked to determine whether those common issues do arise and can be determined along that chain, step 1 and step 2.
But haven't you got to decide that before you get into a trial?
Well, you
say... You can't just turn up at a trial sort of with a a la carte menu and be unclear which issues are going to be determined on a representative basis and which aren't.
Well, we say this. The question on the clear question for trial is to focus on the standard terms of business. And then it's simply a question of working out if there is if the standard terms of business mean what we say they do, and a payment was made, which is part of the class definition. Does breach follow? Does liability follow? Do the various forms of relief we seek follow? Now, where what of course Mr. Justice Robin Knowles will have a discretion to consider is whether some individual factor means that, in fact, having heard the argument, he takes the view that some class members do not have there is some individual factor relating to a class member. For example, it might be the case, and perhaps I'm expressing this badly. One of the things that we have suggested the court has the flexibility to do is to consider and allow individualised defences to be made, to be advanced. Now, those are things that the court, the judge, will have to grapple with in due course.
But that's not one of the things, Mr. Leslie. That is critical. Now, we must approach this on a legal basis. And the legal basis is as follows, that the Supreme Court has told us that you can, as a matter of substance, bifurcate issues that the court wishes to try on a representative basis. But as both my lords have been, if I can put it this way rudely, banging on about, is that they need to know, and I need to know as well, what are the issues that can be determined on a representative basis. And I think it is there a duty under the terms and conditions not to take a secret commission without telling the punter, whatever the client. And that is, you say, something that Lord Legate would be prepared to bifurcate and allow to be tried on a representative basis to bind the class, right? There is then a second stage, and I think you nearly got there by saying at a second stage, there may be a million defences for each of the million people affected by this, limitation, knowledge, fully informed consent, the Bambatch defence of you'd already instructed them through Australia, blah, blah, blah. Now, what I need to know is, one, what are the issues that you say can be tried in words of one syllable on a bifurcated basis pursuant to paragraph 58 of Lord Legate's judgment? Two, what is the trial going to achieve in relation to Bambatch? Is it said that having determined the representative, the common issues of the class, that the case will have to go on to decide whether there is liability in Bambatch because of the particular circumstances of Bambatch? And those are the two things I need to know the answer to, and then I need to know the answer to Mr. Machel's submission, which is that there's no point in determining your representative issue because the question of duty depends on knowledge and scope of instructions. All right? Those are the answers to the questions I'd like to hear.
So, addressing the first of those questions, the common issues of these, do the duties that we've identified at 14 and 15 of the list of trial issues arise on the standard terms of business? That's the first common issue.
Sorry?
So the issues that we have identified at paragraphs 14 and 15 of the list of trial issues, that's at page 487, do those issues arise?
Well, I mean, I hate 14 because it's open-ended. What duties? I mean, a list of issues needs to say, is there a duty to act on an impartial and disinterested basis without conflict in relation to the renewals of the IP rights of each class member? or not? The answer is yes or no.
My lord's formulation is clearly preferable. It's that precise issue that we say can be determined on a class basis.
And then the second question is, if a payment was made, a secret commission was paid, does that give rise to liability? And the answer is obviously yes, if the answer is to one issue.
Subject to defences.
Subject to defences.
Subject to defences,
Yeah.
yes.
So those are the two issues, or maybe it could be formulated as one.
Could I, as I understand Mr. Matchell, he would say that issue 14, as reformulated by my lord, doesn't admit of a yes/no answer. The answer is it all depends, and that's the debate we're having. What do you say the court should do if he is right about that, and that it does all depend? Because we understand what you say the court should do on your case, which is that the answer is yes, and they should just say so, and it should bind everybody. What happens if Mr. Matchell is right? And the answer is it all depends. It depends what Marks Clerk were asked to do and when they were asked to do it. That's what he addressed us on yesterday.
Can I just interpose and say, surely the answer is, if the answer is it depends, then the answer is no, because we need to put some more words into the issue that says without more. In other words, automatically, effectively. And if the answer is no, then you have failed on the common issue.
And if the answer is no, not only you will fail, but everybody will fail, because if the question is tightly enough drawn, it applies to absolutely everybody, which is the basis of a representative proceeding. But if you win on the narrow issue as defined by my lords, it gets you only so far, but then the judge presumably can then say, okay, we've got to base camp, and now I need to look at whether to move any further. Then there are further common issues that can be determined on a representative basis, and if it's all on an individualised basis from here, then no more representative order. Anybody else will have to take the benefit of the adjudication so far and then pursue their own proceedings if they want to. Is that the way it works?
Well, that's correct. The res judicata attaches to the common issue. Yep. So that common issue will be decided across the class. That's clear. And so that's why it's important. I entirely agree with and adopt everything that my lords have said. The critical point is to define the common issue, such that that is the res judicata that arises. If individual claimants, class members, have bespoke arrangements or particular additional facts on which they want to rely that they say gives rise to a duty outside of the standard terms of business, well then that's an additional and separate question. And indeed, in that respect, one recalls the position of Mr. Lloyd in Lloyd and Google, where he sought to advance his claim by reference to a de minimis set of facts. It's called the lowest common denominator approach. And my lord, the Master of the Rolls, at paragraph 75 and 76 of the judgment of this court, it indicated that if particular users, as was inevitable, had suffered additional damage particular to them because they were particularly heavy internet users, then there was no reason, that the flexibility of the procedure could not accommodate those individual claimants in grafting on their claims for much higher amounts, depending on their own particular individual circumstances.
But you see, if that's right,
It was a different case.
Mr. Justice Knowles' apparent decision, as I understand it, is that to allow a representative claim to proceed on all these questions that in tab 45 at this stage, I mean, that goes too far, doesn't it? I mean, he should be biting off a little bit less, a more narrowly focused issue to be determined on a representative basis, and then seeing whether, as it were, a further representative order should be made once he's determined that issue, rather than saying these are all suitable for representative representative proceedings, and they'll sort of decide all that at trial, which seems to be the way. I mean, I'm not blaming Mr. Justice Knowles. I mean, you put this to
The fault in that respect is in the presentation.
You haven't got a respondent's notice either.
That's
So
correct.
if we're going to be tinkering with his order, we're going to be flying by wire.
Well, we're not actually hearing an appeal against this order.
No.
We're hearing an appeal against a much earlier.
Yeah.
And that earlier order was, in a sense, addressing the matters at a level of generality because it was in an earlier stage of the proceedings.
Well, what order did
we-
he actually make? I'm sorry to...
That is the order appealed against.
He dismissed an application by the defendants just under 19.62, as it then was, to say that you couldn't go forward.
And there were two elements to the way the application was brought for the judge. The first element was that he should strike out the claim on the basis that full causes of action had not been pleaded in relation to each individual class member. And for the reasons I explained last night, we say that's simply wrong in law. We can come back to that, but it's not a necessary part of a plea of a representative claim that every single fact relating to every single class member is pleaded. That's just clearly not correct. So that's the first part of the judge's order. We say plainly right. And then the second part of the order was refusing to make a direction under 19.6 sub 2 to order that the matter should not proceed on a representative basis. So the order is cast in wide terms. And what we say is...
the order, is it one at tab 8 of the core?
Tab 7.
Tab 7.
And you need to look at the tab 16, which is the application notice. Because all he does is dismiss paragraphs 1, 2 and 4 of the applications notice, which is at page 174.
I'm grateful, and it's that and the appeal is brought specifically against two elements of that order, and one sees that in the appellant's notice at tab 1 of the core bundle at page 6. It's the refusal to strike out and the refusal to make a direction under CPR 19.6 sub 2.
But the difficulty of this is, I mean, if that's the extent of the appeal, it would leave the subsequent position uncertain.
In that respect, the submission I sought to advance yesterday afternoon was that, as Lord Justice Mummery recognised in Emerald Supplies, in a sense, once one discerns that the court's jurisdiction is engaged and that there are common issues, there's the same interest, and once the court exercises its discretion to allow the case to proceed, the refinement and definition of what are the suitable issues for trial is a matter we respectfully suggest of case management. Now, what I can't do is rely on case management to answer a point of principle. I accept, but we say that in principle, this is a case that can proceed on the 19.8 basis. And if this court is satisfied that that's correct, then the judge's order was well made.
But the trouble is, we now see how the judge proposes to proceed and exercise his case management discretion, as you put it, which is potentially including matters that seem not to be limited in the way that we've been discussing.
And perhaps just to take, as it were, two elements of the representative issues. There's a factual substratum which has always been consistent from the beginning. That is the standard terms of business. And then there is the articulation of how tightly to define the issue as to the duty arising. One of the elements of Mr. Justice Robin Knowles' decision on the list of issues was that he accepted that refinement might be desirable to that list of issues. It appears on the face of his order of the 14th of November. And of course, he was faced with a difficult problem, because he was presented with a suggestion from the claimant and a, as it were, root of branch objection from the defendants. Now, ahead of the CMC on the 26th of January, further definition of that common issue, of the appropriate issue, there may be value in revisiting that formulation, but that a common issue arises, we say, is indisputable.
Well, you have to go further than just there is a common issue. You have to get over the discretion hurdle.
And so, to address the other point that was raised against me in relation to individual pleadings and discretion, we say, as I've explained, that the potential existence of individual pleadings, individual defences rather, is a matter that goes to the discretion of the court, exactly as my Lord the Master of Ross has identified. The question is...
But I mean, you've still got to deal with Mr. Mitchell's absolutely main point, which is that there is no common issue, because it all depends on the nature of the instruction and knowledge. So we need to get to that pretty quickly, because that's pretty critical, if you're right.
That's correct, and it may be, I was planning to take that discretion
Or
point...
if you're wrong.
I was planning to take that discretion point head on
No,
at the end of my
discretion point, that's the substance point.
But I'll leave that. I will certainly come back to it, because we accept it's critical. As to the substance, the first point, if I might just turn immediately to the terms of business themselves.
Yes.
Because there are some things that we say need to be extracted from that document that are important to the way that wood duty arises. Now that's at tab 17 of the core bundle. And of course, the court wasn't taken to this document during the course of my learned friend submissions. We say it's important to see how the duties arise in their context. Now, starting at the top of the page on page 178, these are standard terms of business. They're said to cover all professional work carried out on client's behalf. They form the basis of the ongoing relationship. They're based on recommended terms by the Chartered Institute of Patent Attorneys. At 1.1, it will be familiar to the court. It's said to apply to all matters in respect of which instructions are received. At 1.3, one sees a supremacy clause where it takes effectively precedent over other contractual arrangements. And then at clause 2.1, it is an assurance is given, or contractual representation made, that all of the partners are members of the Chartered Institute of Patent Attorneys, and that they must comply with the respective codes of professional conduct issued by those bodies. It's common ground that those codes of conduct prevent conflicts of interest and require attorneys to promote the interests of their clients. That is then reflected in express contractual language at 2.2, which, as my Lord Justice Snowden observed yesterday, includes both an obligation to put client interests foremost and an obligation to avoid conflicts of interest. Now, I'm going to come back to this page in one moment, but just going forward to clause 4, this is under the rubric instruction of third parties to act on your, as the client's behalf. Now, at 4.1, it says that we may, as part of carrying out the client instructions, be required to instruct third parties. That may include instructing them directly on your behalf. At 4.2, it is said that such third parties they shall endeavour to select third parties whose performance and expertise we regard as being of good quality. So there is, where a selection of a third party is made, there is an express representation as to their abilities. And then at 4.3, it said that the services, capital S, will not extend to issuing you with reminders for and processing the renewals of any of your registered rights. So there are two carve-outs, but they are specific carve-outs. They only relate to for the issuing of reminders and the processing of renewals. There is then, as the court has seen, an authority granted to MNC to instruct CPA to issue reminders to registered proprietors. And it suggested that CPA will invoice those proprietors for their services under the separate terms of business. Now, what is, we suggest, significant is that it is a mandatory feature, therefore, of becoming a client of MNC that one grants an instruction to MNC to instruct CPA on the client's behalf. And there's a further feature, because turning back to the previous page at clause 3.4.
Sorry, the client authorises Marks and Clerks to instruct computer patent annuities not to act on your behalf, not to act on the client's behalf, but to remind, to do certain things. When you said on, can you give me the formulation again? Because I don't think that it's, as I understand it, what the client is doing is saying, we authorise Marks and Clerk to effectively give our details to CPA so that CPA can remind us or our appointed representatives of the due dates for renewal, etc., etc. But I don't think there's any other authority to act on behalf of the client. It's simply a consent to the release of data, isn't it?
That's great. It's an instruction to receive a specific service, which is a reminder of upcoming renewal dates from CPA, and then it's suggested that CPA may, where it renews, it may charge for its services separately. Now, but there's an
the word. It's the wording is odd, but it's not actually an authority on behalf of the client, other than to release data, isn't it? Is it?
Well, there's an interesting feature. If I can take the court to clause 3.4, it's significant. Clause 3.4, there is an overriding instruction to let rights lapse. Now, of course, as the court will know, if a renewal fee is not paid, then it lapses. Once it's lapsed, it's lost forever. And so, as part of the terms, it is said that the overriding instructions are not to let your rights lapse without specific instructions to do so. There may be occasions when a third party instructed by us on your behalf has to take urgent action thought to be in your best interests without recourse to our firm or you. Such action will be within the terms of the overriding instructions. So,
that's not actually one of the pleaded provisions of the contract that you rely on in your pleading. So why do you say that takes us any further?
Well, we say it is what this contract does is it requires clients as a condition of becoming MNC clients to grant a series of authorities and waivers in favour of CPA. So, for example, and just to address specifically the point raised by my Lord Justice Snowden, at clause 9 turning forward, one sees a provision of a classic confidentiality obligation. Obviously, those confidentiality rights are waived as against CPA as a necessary part of the 4.3 instruction. And at clause 10.1, one sees data protection rights, in respect of which there is the client is required to give a mandatory waiver as regards CPA unless there is an explicit instruction to the contrary. That's a further element of the instruction. Now, one further and final point, and it's simply illustrative of the way in which 4.3 and 2.2 operate together. Those are the two critical terms. Together
Sorry, just before you move on, you said a moment ago that it was a mandatory requirement of becoming a client that the client authorise Marks Clerk to pass details to CPA. 10.1 seems to suggest the client can give instructions not to do that, so that it's not mandatory, it's a default position, but it's not mandatory.
But my Lord Justice Nugee is entirely right, and I had thought in my submissions I'd drawn attention to that element. It is of course critical that there is a possibility of a counter instruction. That's not the point that in a sense it doesn't turn on that. The point is, we say that as a mandatory part of becoming an M&C client and being bound by these terms, one grants a waiver of DPA rights subject to express counter instruction.
Right, thank you.
And then at 15.2, under the rubric conflicts of interest, one sees that there are assurances given as to the procedures and arrangements that protect and prevent misuse of confidential information. And it says at the end of that clause that we will not make use of any information confidential to you to the advantage of any third party. Now, of course, that is significant in the context of clause 2.2, because as we know from the existence of the service agreements, the confidential information of the clients was being used to advantage both CPA under the express terms of the service agreement, and also the second appellant, LAR, which was receiving substantial commissions on the basis that confidential information was being released to CPA, and CPA was paying commissions.
Well, I mean, these are arguments for trial, but 15.2 might be said to be subject to the express permission. I mean, in a sense, it's obvious that potentially it's going to be for the benefit of CPA to have the client's renewal data released to CPA, because CPA is in business. That's not really the complaint here. The complaint is about the payment back. It's not that CPA is making use of the information confidential to the client, because that's apparent on the face of clause 4.3. That's not a complaint. That's not a breach of contract. I mean, you're not saying it's a breach.
No, what is striking is that the confidential information is being used to the benefit of second appellant.
But your claim is not. Your claim is avowedly not for breach of 15.2. You never suggested it is. So I'm not sure how it really helps you just to point to it.
Well, and I entirely see the force of my Lord's point. It is to establish the contractual framework in which the critical terms of 2.2, 4.2 and 4.3 are to be understood. And what is meant by the undertaking given by M&C at clause 4.2 to put client interest foremost and to avoid conflicts of interest. And that's why I illustrated, because of course this is under the rubric conflicts of interest. But what I should do now is, just having given, as it were, the detail of those terms, I propose to go straight to Wood to tackle the legal point that is taken against me. So, in fact, if I might just take the court to one further point, just for the note, but it's helpful just to turn it up before I move directly to the law. At tab 18, these are the 2018 terms about which no complaint is made. But it may be that the court hasn't seen those. If I could take the court to clauses 4.3 and 4.4 at page 185, just so that they are firmly in the court's mind. 4.3 establishes the very same structure for the making of renewals, for the issuing of the grant of an authority to M&C to instruct CPA to issue renewal reminders. And 4.4 makes clear that there will be a payment made in respect of that work, and that the transfer of data to CPA, effectively all of the work done under condition 4.3 amounts to a service, capital S. And of course we know that a service, capital S, is an act that is subject to the full extent of the contractual protection set out in the terms of business. So one sees at page 185, the definition of services, it's identical to the definition of services in the earlier terms of business. And of course it's those services, so it's common ground, that if a service, capital S, was provided, then a duty of no conflict was owed under clause 2.2. And indeed, that is admitted in my learned friend's amended defence and counterclaim at paragraph 26.4. So that's the factual context. Turning to the law, clearly the critical decision is wood and commercial first business. And that's at the authorities bundle, if we can turn it up immediately. It's at tab 18, and it starts at page 516. And my learned friend has gone through the background to that case. I shall just address one factual point and then move straight to the principles. At paragraph 16, that's page 529, because it illustrates a point that's taken later. At the top of the terms of business that were at issue in the Pengelly case, there were 3 levels of service. Full advice, as was the first. Second was information on different types of mortgage. And the third was information on a single product only, where no advice given. And the reason I make that point is that in due course, the Lord Justice David Richards is clear that it was the third sort of service that was provided. So it was an attenuated service. Moving forward to paragraph 47. Here it said that the precise duties that brokers require examination by recommendation.
Which paragraph? 27?
47.
Sorry.
And it's 47, 48, and down to 51. These are the paragraphs that my learned friend took the court to. Mm-hmm. The critical point is at paragraph 48, which states, and this is 48, it's one sees it at the second sentence. It is in a sense a simple question, whether the payee was under a duty to provide information, advice, or recommendation on an impartial or disinterested basis. And if the payee was under such a duty, the payment of bribes or secret commissions exposes the payer and the payee to the applicable civil remedies. No further inquiries to the legal nature of their relationship is required. So if one has a recommendation and it was required to be given on a disinterested basis, a non-conflicted basis, then mere receipt of payment is sufficient to trigger liability. The court doesn't need to look any further. And at paragraph 50, just going down the page, the final sentence, Lord Justice David Richards makes clear that it's the content of the duty that matters. So where we have articulated a common issue, being a duty to avoid, or not to act on a partial basis, not to act on a conflicted basis, whether you label that fiduciary or non-fiduciary is nothing to the point. Now, of course, there's an interesting issue there, because the duty can be articulated in 2 ways. Lord Justice David Richards articulates it effectively in the negative. It's a duty not to have a personal interest. But of course, another way of articulating that same point, it's often articulated this way in the authorities, is it's a duty to disclose if you do have a conflict, or if, for example, you do receive a payment. And we say that is significant because it shows that the question is whether you are in a position of conflict and nonetheless receive a payment. That's the extent of the inquiry.
So you say that, what, 4.3 is a recommendation of somebody to perform renewal services, and the question is whether Marks and Clerks were under a duty to provide that recommendation on a disinterested basis.
It's 4.3 with 4.2. 4.2. I mean, one of the interesting things about this
4.3 construed in the light of 2.2.
4.2 and 2.2, as it were. 4.2 is the express recommendation.
4.3, I think so.
So 4.3 is the authority, and the selection, as it were, in presentation. That is page 179 of the core bundle, just from my Lord's note. So 4.3 is the authority, the selection and presentation. That on its own, we say, on the basis of would, connotes an implied representation as to the quality of the service. But where we are a fortiori would is that at 4.2, it is said that where a third party is identified and selected.
Yes, but that's only where the third party is instructed, pursuant to clause 4.1, to act on behalf of the client. That's not what's happening with CPA. 4.1 and 4.2 are where, for example, Marks and Clerks would engage a firm of solicitors or firm of lawyers in a different jurisdiction to act on behalf of. So they're engaging on behalf of the client, somebody else, and the duty is to select them carefully. But that's not what's going on here, surely, because Marks and Clerk are not engaging CPA to act on behalf of the client. They're giving CPA the wherewithal, the information that CPA can approach the client direct. I don't at the moment understand why 4.1 and 4.2 are actually relevant to this case at all.
Well, there's, of course, we will
Anyway,
suggest...
that would be, but that's in a sense a matter for trial.
My Lord has my point. That is exactly... We will be making this submission at trial. We may or may not be right about that. But in a sense, we don't need it. All we need at 4.3, there's a selection and presentation. It's clear that is on the authorities an implied recommendation at least. Yeah. And of course, when one looks at the recommendation and then construe that against in the context of clause 2.2, it's a recommendation made where there was a duty not to act in a conflicted way. Now, the next point I would just take the court to briefly is at paragraph 82, where we say there's an elision in the way that my learned friend addresses this point, because, and it's the point I made earlier, but just for the court's note, that as Lord Justice Tuckey made clear in Hurstanger, quoted here, a bribe is a special category of fraud in which it is unnecessary to prove motive, inducement, or loss up to the amount of the bribe. So we say that once you have a recommendation and a duty to act in an impartial way, then whether or not that had an effect on the client, whether it induced some particular act, is not relevant. Now of course, we say there's a good, in a sense, this case is a good example of why that is. If it were the case, we posit rhetorically, that M&C had disclosed to its clients that up to 60% of the renewal fees that they were paying to CPA for their renewal services were being routed back to a partnership made up of the individual partners of M&C, the very clients, lawyers who were providing them services, we say that is very likely to have led those clients to imagine first that they were being grossly overcharged by CPA, and secondly to revisit their contractual relationships with CPA. But in a sense, the critical point is that the law doesn't require the court or the parties to grapple with that evidential question.
No, but
It presumes it.
But the trouble is, you've just leapt ahead of Mr. Mateshaw's point against you, haven't you? Because his point is that, so far as Bamback Europe is concerned, actually there wasn't a recommendation which was operative in this case, because this contract, the recommendation which you rely upon, was signed the day after Bamback Europe was approached by or approached CPA. So you may be right in relation to other people, but Mr. Mateshaw's point is that Bamback Europe actually didn't receive an operative recommendation pursuant to these terms and conditions, because it had already been recommended to CPA by Bamback Australia. And that's his core point, as I understand it, as to why Bamback Europe is not an appropriate representative party.
And we would say two things. First of all,
I mean, unless I misunderstood it,
that's as I apprehend the point taken against me. Now, the first point is to say the reference to an operative recommendation, we say that's the wrong question, because if a recommendation is made, whether it is operative is the sort of question that Lord Justice Tuckey is clear the court does not have to grapple with. And the way to test that is by articulating the would duty, as I say, not negatively but positively. Was there a duty to disclose? Now we say if the payment had been disclosed, the existence of the payment had been disclosed, so they said, as they do in the 2018 terms, we are going to instruct CPA.
Was there a payment in Bamback?
There were payments.
Were payments?
Yes, that's common.
So you say it doesn't really matter, because whether the recommendation was operative or not, you were under duty not to take a secret commission.
Yes.
Full stop. Story.
That's exactly right.
Because of your connection with us.
And it's exactly by articulating the duty in a positive sense and saying, well, what would be the position if they were under a positive duty to say, we are taking up to 60% of the fees you pay to CPA back, and it's on that understanding that we are nonetheless recommending CPA to you. The approach the law has adopted is that it doesn't need, there's no further inquiry needed. It presumes against the agent that the recommendation was operative.
And you say the scope of the instruction, the details of the instruction, knowledge about the instruction is all totally irrelevant if a secret commission is paid in the circumstances of a relationship of this kind. Under these terms and conditions, liability follows for the amount of the payment.
That's correct.
Full stop. End of story.
Full stop.
Yeah, very simple.
And I shall return to Hurstanger because there's an important further point on defences. At paragraph 88, just moving forward in wood, there's a brief description of Medstead, and it was found that there was no advice or recommendation, but that actually the mere presentation, I'll come back if there's a further authority on this point, but the mere presentation of the...
So where are you looking?
At paragraph 88, and it's letter C, that there was an implied representation that by the mere presentation of a firm, that the terms offered by that firm were competitive. And at paragraph 92, passage that my learned friend took the court to, it's the question is whether there's a duty to be honest and impartial. Again, we say that's a helpful touchstone. Were they undertaking to be impartial, to do what they did impartially? Moving forward then to the articulation of the duty at 102, again this is a passage that's what's been taken to, but it is this duty to be impartial, to act on a disinterested or non-conflicted basis when providing advice or information or recommendations. And there's an interesting further exemplification of that.
I mean, but just to be clear, this whole section of Lord Justice David Richards' judgment is dealing with a slightly different point, isn't it? He's dealing with the question of whether there's a need for a fiduciary relationship, or whether it's simply sufficient that there's a duty to provide disinterested advice. I mean, you're, as I understand it, you're going further. Is this right? And I mean, in a sense, I question whether we need to. I'm not sure why we're deciding this, but you're trying to say, is this right, that if you're right, the Banbach Europe point defence is irrelevant. But the question is, can you formulate an issue for determination on a representative basis on which you may be wrong in your proposition?
And the one articulation was that of my lord, the Master of the Rolls. It may be that some additional precision can be introduced to the way in which it's defined, but the question we would respectfully suggest for the court is there a same interest? Is there a common issue here? And then there's a matter of discretion. Can it be can it be presented in an attractive way at trial, such that it is useful and desirable for that issue to be decided at trial and establish a res judicata as across class members? And we say that the duty, what we extract from Wood, is that only two elements are needed, and that the duty in question can be taken from only the question as to whether, for example, a recommendation or information was provided in circumstances there was a duty to be impartial. It's a very, very simple formulation by Lord Justice David Richards. And perhaps just to give, as it were, a concrete example of how that is applied, if one goes over the page to 106, one sees the circumstances in which such a duty might arise. And it's said that it arises, this is at 106, 4 lines down, that even where an agent gives no advice or recommendation, but instead simply proposes or arranges a particular contract, there is at the very least an implied representation the proposed contract was competitive. And
So 106 of what?
of Wood, I apologise, of Wood, that's page 549, tab 18 of the authorities bundle.
Yeah.
And the point made there is that all that is required, it doesn't even require an express piece of advice or recommendation. Simply proposing a transaction, simply arranging a contract, connotes at the very least an implied representation that the proposed contract was competitive. Now here it's clear that there is a proposal of a contract, of an engagement with CPA, and an offer, in fact, to act as as it were, the liaising party between CPA and the client. So in fact, we say, again, our case goes beyond the de minimis facts that are required to establish the Wood duty as per those other decisions in McWilliam and Medstead. Interestingly, Medstead, I might just take it now, I won't take the court to it, but that was a case where there was no written contract at all. And indeed, it was the point taken on appeal by the broker was that there was no contract at all. And the judge, that was what the judge was dealing with there. It's a very different scenario where one is looking at a clear express written terms that we say clearly, we respectfully suggest, include a representation. Just moving on from there, and I'll just take this point very, very briefly because I feel I've extracted the core points from this authority. But at paragraphs 107 and 108, and then going to 110, the judge at first instance, Mr. Justice Marcus Smith, had operated on the basis that it was necessary to show a fiduciary duty. And he went beyond the first instance judge. The appeal before the Court of Appeal was a second appeal. He went beyond the first instance judge and said that various services were provided, that in circumstances where the first instance judge had said that the parties had only operated on the basis of a level 3 service. And that's what I showed the court at the outset. It was the mere provision of information about one transaction, no advice. And the point they made, the broker made, was that their role was purely administrative. It was, and what the Lord Justice David Richards found at 108 was that the judge of the Chancery Division had fallen into error. It wasn't open to him to make the wider finding as to what services were provided, such as to found, in his judgment, a fiduciary duty. But at 110...
Sorry, isn't 108 recording the appellant submissions?
That's correct. And at H, 108H, it said that the trial judge had made these findings. It was not open to him as sitting as an appellate court to go further and say that there was some obligation to find the best deal on the market. And the broker was providing packaging services which were entirely administrative in nature. And so it was that very, very narrow factual basis for the claim that Justice David Richards said was the correct one. The judge on the first appeal was wrong to go beyond the finding that there was simply a...
Where does he say that?
Service.
I read the whole of 108 as simply recording the submissions for the appellant.
And then 109 says the same arguments were advanced by the appellants on their appeal, and then 110 is his finding.
Sorry, and I should say, what I the critical bit is, and my lord is entirely. I have leapt forward to 110, where what Lord Justice David Richards finds is that it was the basis of the broker's terms and the findings of fact at first instance. That is, it was not. It was in a sense accepted. It was no, as it were, criticism of the judge of the Chancery Division, but it was accepted that just on the basis of an administrative set of services, that was sufficient to engage the wood duty at 110.
Yeah.
Now, having set out those, having taken the court through that judgment, I should just take very briefly 4 points on wood, which it may be that I can truncate in light of the way the argument is developed. We say, first of all, just addressing directly the question asked of me by my Lord the Master of the Rolls, that it is necessary to establish some potential knowledge of commissions associated with the clients as a necessary part of establishing the cause of action, or even presenting the cause of action. And as I foreshadowed, we say that this aligns questions of duty with questions of disclosure. And an example of this is in fact Wood itself, where there is a question as to whether there was a secret commission was paid. I'll come to that in 1 second. But we say that where the question of disclosure arises, the best authority is Herstanger. That's Authorities Bundle tab 7. It deals directly, we say, with this point, and it quotes Boasted and Reynolds. Now, that is at page 142 of the Authorities Bundle. And so that sets out the background via the head node. And the critical point I would like to take the court to is page 153. And starting at paragraph 34, it said that the broker could only have acted in this way, that is by receiving a commission, if the defendants had consented to his doing so with full knowledge of all the material circumstances and of the nature and extent of his interest. An agent who receives commission without the informed consent of his principal will be in breach of fiduciary duty. Third party paying commission will be an accessory, and then the remedies follow. What amounts to sufficient disclosure for these purposes, Lord Justice Tuckey asks, and quotes Boasted and Reynolds for the proposition that consent must be positively shown, and the burden of proving full disclosure lies on the agent. It's not sufficient for him merely to disclose that he has an interest or to make such statements as would put the principal on inquiry. Nor is it a defence to prove that had he asked for permission, it would have been given. And Lord Justice Tuckey says that that is an accurate statement of the law. Whether there has been sufficient disclosure must depend upon the facts of the case. Now, what we say is important there, we say a couple of things are important, but just as a starting point, addressing the question of my Lord the Master of the Rolls, it is clear that alleged or actual partial knowledge, question of whether a principal is on inquiry, none of that matters. None of it goes to the existence of the duty. It affects the defence. And in relation, secondly, to that defence, the burden is on the agent to plead and prove it. Now, this is going to be very important when I return to the question of discretion and grapple directly with the point that my Lord Justice Snowden and the Master of the Rolls have each expressed as to what happens next. What happens if individualised defences are advanced? But I'll leave those submissions for the end of my submissions this morning. And of course, turning then to my second submission, which arises out of the first, what one often gets in cases, say often, occasionally gets, is an argument, which is foreshadowed in Boasted and Reynolds here, that there was some disclosure, but that it simply wasn't sufficient. And that gives rise to the category of cases known as half-secret cases, half-secret commissions. Now, this was a point, in fact, taken lately in my appellant's supplementary skeleton argument. And we say, for a number of reasons, it's a bad one. But the critical point, and in fact, one sees it in Wood. We say it's a bad one for two reasons. First of all, because it's necessary to show consent. So to make out the defence, it's disclosure and consent together. And then the second reason why we say it's a bad point is because in Wood, and one can pick it up at 554 of the Authorities Bundle, it's the very last judgment paragraph of Lord Justice David Richards's judgment. The judge held that in circumstances where the terms of business provided that the amount of there might be commission disclosed, or might be commission paid, but that amounts would be disclosed. The fact that there was no disclosure meant that the commission was fully secret even though, in a sense, the individual borrowers in this case were put on inquiry by contractual terms saying that commissions might be paid. And he said that the positive representation that there were no, the statement that commissions would be quantified, combined with the fact that there was no disclosure made at all, amounted to essentially a positive representation that no commission on this case was paid. Now we say, of course, on the facts of our case, we're exactly in the same position. We say there's a positive duty on the face of the contract not to act in a conflicted way. So that is, in a sense, we would respectfully suggest a much more direct form of representation that no secret payments are being received by M&C. Much more direct than Lord Justice David Richards discerned from the terms in Wood. So that was the second point on the law in Wood. I can take the third.
Just before you leave that, if it were a case of half-secret commission, Mr. Machell relies to some extent on what he says. Some people would just know that this was standard practice in the industry because they would have been told by their overseas attorneys or whatever. I think Lord Justice Tuckey in Hersteiner says, well, that might not give you a defence to equitable remedies for breach of fiduciary duty, but it would mean it wasn't the tort of bribery. Now, as I read your list of trial issues, we're only going to ask for decisions on the tort of bribery and not on breach of fiduciary duty. Is that right?
Well, we say two things. First of all, the focus is always on the duty, and whether the duty is fiduciary or not is we say a collateral point to whether a duty of no conflict is owed. That's the paragraph 50 of Wood. We have identified the duties to encompass that very question of no conflict. There's then a second question, which is in relation to the we say in relation to whether or not a remedy is available. We say that the facts that the duty we've identified gives us a path to establishing liability in the tort of bribery, regardless of knowledge, because the knowledge is part of the defence. We say it's not part of the underlying duty. Now, if it is the case, and of course we maintain all of our pleas, and we've suggested all of our pleas on the representative basis to include all of the equitable relief we seek. We are trying to put together two parts of a cause of action: duty, and then a payment establishing a liability. We consider that if those two parts are put together, then we succeed on bribery, notwithstanding any particular circumstances. If the court were to consider that bribery stands apart from fiduciary duties, and the analysis of the tort of bribery stands apart from the law relating to commissions paid in breach of fiduciary duty, we would respectfully say two things. First of all, we can't see a principled basis for the distinction. Given the judgment of Lord Justice David Richards, the focus on consent to secret commissions in Herstanger is proceeding on the basis that a fiduciary duty needs to be established. But of course we know that it doesn't need to be established. We can't see any reason in principle why bribery and fiduciary and a fiduciary relationship within in those circumstances be different. The second point is a practical one.
Sorry, but just pausing there. I mean, whatever you think. My Lord has just pointed out to you that if in paragraph 128 of Lord Justice David Richards' judgment referring to Herstanger, he appears to summarise what Lord Justice Tuckey decided without criticism as half-secret commission negates secrecy, which I understand is an element of bribery, the tort of bribery, but insufficiently disclosed to obtain the borrower's informed consent, which is the fiduciary duty argument. So he does seem to accept, at least arguably, that if there is a half-secret commission of the type that my lord put to you, that there might be a difference between liability in the tort of bribery and that for breach of fiduciary duty. And the problem that I think my lord is putting to you is that that seems to infect what otherwise you say is a very straightforward question with considerations of industry knowledge that these type of commissions are generally paid.
Well, and we respectfully suggest that it's a category error because it's a misuse. The word secrecy there is used in a very technical sense. It's important to keep that sense firmly in mind. The passage that I've shown the court in Herstanger is clear that secrecy is not negated even where partial disclosure is made, even where the principle is put on inquiry.
But he's dealing in that passage, 34 and 35, with Bousted and Reynolds. Bousted and Reynolds is about the defence to an allegation that there's been a breach of fiduciary duty. The defence is fully informed consent. What he's saying is it needs to be fully informed, and the onus is on the defendant. But he goes on shortly afterwards to say, in this case, there was disclosure of the fact of commission, but not the amount. That's not fully informed consent, but it does negate fraud, which is an ingredient of bribery, and therefore it would be wrong to convict this defendant of bribery. Now, whether you like it or not, that is what the Court of Appeal seems to have said in Herstanger, which does seem to draw a distinction in cases of half-secret commissions between whether it provides a defence to breach of fiduciary duty, answer no, because it's not fully informed, and whether it negates the tort of bribery, answer yes, because there's no fraud. And as my lord points out, nothing said in Wood seems to, even if it could, depart from that analysis. Now, what I was asking was, is it right that the case you're going to put forward at trial is limited to the tort of bribery and does not extend separately to breach of fiduciary duty? And I don't think you've answered that question. You've said why in your submission you ought to win, but that's not the question. The question is what's for trial? What is the issue for trial?
And just to tackle that, I was looking to, or intending to develop my submissions by reference to two stages. The first was the principal stage, that is the one I've identified. The second one is a pragmatic one, which is we say that once the duty of no conflicts is established, regardless of the label put on it, and a payment and breach of that conflict is established, then relief follows. That's our thesis. Now, we have identified the relief following through the tort of bribery, because we take a different view as to what amounts to secrecy for the purposes of the tort of bribery. We say that secrecy it's about disclosure and consent, and that's always the focus on in the question of secrecy. I recognise entirely my lord's point that it may be that in seeking to streamline the issues to focus on that point and leaving the fiduciary, the express reference to a relief in respect of breach of fiduciary duty, it is possible that it would be advantageous for that to be reintroduced. But there's no question that we are asking for a finding that there is a breach of the duty, the no conflict duty that we've identified. And if I can take the court to just the
what is this
the issue.
duty? Is it contractual? Is it equitable? Is it tortious? What is it?
We would suggest it's an equitable duty, but it is in fact on the face in this case, it is one has contractual duties, tortious duties, and equitable duties. There's a contractual duty to put client interest foremost. There's where we situate our case
And you're
is
pleading,
in relation.
and you're pleading you expressly disavow a claim for breach of contract.
And there are three categories of duty, and the ones that we have sought to advance. So, sorry, I should explain. There are three categories of duties that arise in this case. The ones that we seek to take forward are tortious and equitable duties. We've always been clear, and my lawyer is entirely right. Always
Where
been-
do I find in the list of trial issues any reference to equitable duties?
So if one sees at issues 14 and 15 of the core bundle, and then turns over the page, those are the duties. I've said they are formulated to capture all of the matters that I have been describing, and going across the page, one sees at 20. We see there's a question as to the receipt of payment, there's a question as to the tort of bribery, and then it is also said, did M&C breach any of the duties set out in those paragraphs? So there is no question that issue goes forward to the representative, to the representative action. The question, and my lord is entirely right, is can that then, if that is established, if duty and breach are established, does that give rise to liability in the tort of bribery, or is it necessary also to add, as it were, the legal classification? It's a liability for a breach of equitable duty, and I can see the force in having that issue decided in one go. But whether there is a breach of that duty is clearly a matter for the initial trial.
Thank you.
But if the question of breach of duty is for the initial trial, then the particular facts of Bambach Europe are in play, aren't they? Because you may be wrong about your 2 points. And this goes back to what I was banging on about earlier. You know, in a sense, you're laying out your story, you're laying out your case. But what we're actually interested in, surely, is what's the issue to be determined on which you may be right, but you may be wrong. You can't assume when you're formulating the issue that you are right, can you?
I would entirely accept that.
So if you're saying one of the issues for trial, the first trial, on a representative basis is, was there breach? Why doesn't that bring in the particular arguments that Mr. Machel wants to advance on behalf of his clients, that you're wrong on the law, and it is a relevant question as to whether there's a breach, that, for example, the recommendation was just in the open air because, in fact, your client had already decided to, independently of the recommendation, to engage CPA.
Well, there are three elements. There's duty, breach, and then whether relief follows. And in relation to duty, we say it's a very simple question. Does the duty arise? Now, of course, it's said against me. There may be ambient facts that mean that the duty doesn't arise. We say that's wrong.
Okay.
So then the second question is breach. And we say if there's a duty of no conflict, then the mere fact of the payment, that breaches that duty. That establishes liability. So all of that can be done on a representative basis. There's then a third step, which is...
I know you say that,
Sorry.
but Mr. Machel says you could be wrong on that.
And where he says... And so that's why the focus, we say, is on establishing what the res judicata establishes. What is it intended to capture? It's intended to capture whether the duty arises on the standard terms. If it does not, then all members of the class are bound, for good or ill, by the determination that that duty does not arise on the standard terms of business. If they have additional and separate matters on which they want to rely, that they say separately give rise to the relevant duty, recognising that, for example, the wood duty doesn't require the existence of a contract, that's Medstead, then that is something that in a sense, there is still open to them to run. So that's why we say we entirely agree and endorse and adopt my Lord's suggestion that the focus must always be on the common issue, because that's the res judicata that gets established. And that's what CPR 19.8 is all about. And the question is it of benefit to the class members to have that issue determined such that there is a res judicata on it, for good or ill, across the class? Or is it better that each class member be left, as it were, to its own devices to try and to argue the issue? And we say that the circumstances of a common contract are a paradigm example. It's the Irish shipping case mentioned by Lord Legate. That's a Court of Appeal decision of Lord Justice Sturton and Lord Justice Purchase. The existence of multiple contracts is no bar to this. It's determining what duties arise out of a contract. A common contract is a classic 19.8 question. I have 2 issues that I should cover. I appreciate that I have under half an hour. One of the points is going to be on 19.8. It may be that we've traversed a number of those in our argument yesterday afternoon and today. But I may just go through those quickly to tackle one point that's made. I was going to go through the individual grounds of appeal, but it may be that that's an unnecessary distraction. And then I absolutely must tackle the discretion point, which of course is recognised as critical. Moving to 19.8, we suggest, and I can take these quite quickly, that there are 8 propositions that I'm going to outline. I can take them, as I say, very briefly. The first of them is that there are only two questions: whether the same interest arises, and then whether to exercise discretion. That's all. The second submission reflects Lord Legate, paragraph 67 to 68, which is that the whole purpose of the 19.8 procedure is to promote simplicity and flexibility. The third submission is as to the meaning of same interest, and for that I will invite the court to turn up Lloyd and Google, and that's at tab 20, page 612 of the authorities file.
Sorry, which page?
612. Here, Lord Legate explains that the phrase same interest requires a purpose of interpretation, and I shall just address one point in relation to same interest, which is the possibility of conflicts. That's adverted to at paragraph 72. And of course, as my Lord Justice Nugee observed yesterday, the problem is not a divergent interest. The problem is a true conflict, a conflicting set of interests. And we say that there are effectively 2 aspects of the same interest test. There's a common issue that affects all class members in circumstances where there is no true conflict, as described by Lord Legate, between the class members as against themselves. And just to address that question, the 2 examples given by Lord Legate are Marked and the Emerald Supplies case. Now, Marked is summarised earlier at 43 to 44 of the judgment. I can take it just very briefly. It involved a case where a claim was brought against a shipping company on behalf of cargo owners where a ship had been sunk, and the ship had been targeted by a Russian warship under suspicion that it was transporting contraband. And the Court of Appeal noted that there was a potential conflict, therefore, a direct conflict, between innocent cargo owners and those who may have been smuggling contraband. That's one example of a conflict. A similar and perhaps even more vivid example is Emerald Supplies. Now, for that, we can turn to 56 and 57 of Lord Legate's judgment. That's starting at page 608. paragraph 57, Lord Legate explained that there was a conflict at the heart of the proposed class. The class was intended to include both direct and indirect purchasers of air freight services in circumstances where the claim sought declarations as to alleged anti-competitive price inflation. Clearly, in a price inflation claim, that meant it was in the interests of the direct purchasers to say that they had absorbed all of those price increases and not passed them on. And in the interests of the indirect purchasers to say that those increases had been passed on to them, such that they had absorbed the higher prices. In both of those two cases, what the court was confronted with was the prospect of class members advancing not simply individual arguments or potentially divergent arguments, but arguments that were diametrically opposed. And that is, we suggest, the touchstone of a true conflict. And of course, what we say is that in this case, even if some class members may have additional arguments, as against M&C, they all clearly, we would respectfully suggest, share the same interest in establishing the existence of the meaning of the standard terms of business as against M&C.
Yeah, the question that's put against you is not that there may be other people out there who may have extra arguments for liability. The argument that's put against you is that your particular client is subject to a particular defence, which, if made good, will scupper all the other members of the class. I mean, it's a, as I observed yesterday, it's a curious argument for the defendants to be running, but nevertheless, they say yours is the least suitable representative claimant because it's subject to an additional defence, which other people may not be, arising out of the particular circumstances. So I don't think there's really much argument that other people in your class may have additional arguments, which is the point you've just made. You're not really grappling with the argument against you, which is that your particular client is subject to a particular extra defence.
We'd respectfully say that the answer to that is by reference to the precision in the articulation of the issue. The issue is about the duties arising out of standard terms of business.
Right, so not breach, because a few minutes ago you tried to add breach in, which is when I sort of picked you up.
Well, that was the breach, in a sense, we say is automatic across the class.
You may be wrong on that.
Well, of course, I accept that, but in a sense, we say...
So given that you may be wrong on breach, is breach a suitable question for representative determination?
Well, we would say this. One has to interrogate what the meaning of breach is. We say that when you establish the duty that we seek to establish, the no conflict duty, breach is the mere receipt of a payment. So everything turns on duty, not, we say in this case, on breach. The question is, do we establish a duty that is such that where a payment is received, that payment is a breach? Duty not to receive that sort of payment, in a sense. So everything turns on the duty. And all of the class members have exactly the same interest in establishing that duty, the existence of that duty, for good or ill, on the terms of these terms of business as against M&C. Now, if, as I say, they have additional arguments where they say other bespoke matters mean that they were owed some additional, different or better duty, then the res judicata doesn't attach to that.
But with respect, we're just going back over the same point. You've just made exactly the same point. It's not that other members of the class may have additional or better arguments. That's the real point made against you. The point made against you is that your particular client is subject to a defence.
Well, we respectfully suggest that one has to look at the issue, the common issue. We say that in relation to that common issue, there isn't a defence that is particular to our client, and that's why I opened to this morning saying that, in a sense, Bambach Europe, we say it's almost a red herring in terms of leading the court to consider the particular circumstances of Bambach in considering whether the duty arises. We say we rely on the representative, so far as the representative action is concerned, we don't rely on particular facts. And we say that there aren't individual defences that affect whether simply on the terms of business the duty arises.
It's not really a trial then, it's a determination of a single point of law.
Well, there's a...
So the outcome is, under these terms and conditions, there would be liability if a payment were made subject to defences that might be raised in a particular case. Which is a bit sterile.
But we say, critically, it is valuable. So that's why we say there are, of course, further questions as to whether, for example, to take my Lord Justice Nugee's example, the tort of bribery is engaged. There are a number of questions as to there's a question of limitation which is being run on the part of Bambatch, which will decide certain, at least on an individual basis, those questions. But we say the question for the court is it's always these twin issues. Is there a same interest? We say there is. And if so, is it desirable for that issue to be determined? If it is an issue of law, it's essentially a question of construction of these terms without reference to particular facts. Then we say two things. First of all, it's desirable for the class to have that issue determined. And secondly, one of the issues here is that where the burden is on the defendant, we say, to plead defences of disclosure and consent, the process of the class action will force the defendants to assume that burden, will require them to plead defences of consent and of disclosure and consent. And so the process has that additional benefit of establishing whether those defences, the extent to which those defences even exist. And that's important because it goes to the court's discretion and its consideration of why this is a valuable process.
Where is the issue formulated on consent?
Well, in relation to consent, we would say that is a defence for them to run. It's true that...
So it's not going to be determined on this sterile legal question?
Well, we say it's on the sterile legal question. We say it's the starting point of the claim is indeed a legal one. But where it ends up, and this is the critical point, once that legal duty is established on the face of this single document, then we say the question, one can move, once payments are established, that's another part of this process, to establish what commissions were paid over the relevant period, which commissions were paid in respect of which clients. And once the duty is established, if it is established, then that mere payment gives rise to two consequences. Liability, and because we're looking at the tort of bribery, or whether it's categorised as a breach of fiduciary duty, an immediate entitlement to monetary relief. And that's why this is far from arid.
Well, I mean, only if you're right, as my lord keeps on saying.
Well, and if we're not right, and let me assume against myself that we're entirely wrong, then what all class members will know is that the standard terms of business have not established a duty on the part of M&C to make disclosure, such that unless they can point to some further and special arrangement or recommendation or event that touches them alone, they have no claim.
Yeah, but the trouble is, you're running together 2 points. 14 and 15, questions 14 and 15, as modified earlier in this morning, might simply raise the question, is there a duty of various types? But is there a duty? Which would be common on the face of it to everybody who signed the terms and conditions, subject to a defence. In other words, you'd establish there's a duty, but you don't get to liability unless you can also surmount any arguable defences. And I think where you're eliding, if I may say at the moment, is that it may well be that the simple question of the existence of a duty is something that could be determined on a representative basis, on the basis of the contract, as a matter of legal analysis of the contract. But as soon as you start saying, is there liability as a consequence, you're into breach. And breach does, doesn't it, raise questions of whether there's a defence. And that's the question. Can that be included at the moment in a 19.8 representative claim? Because you're susceptible to, well, A, you may be wrong about your as night follows day breach follows the establishment of the duty on these facts. You may be wrong, but you may specifically be wrong in relation to your client for the very particular factual circumstances of your client. So the real question for us, I think, is not whether you are right or wrong, but whether it's appropriate for this case to proceed, not just to deal with questions of duty, but also breach.
And the question of breach there, I understand to put in issue the sorts of defences that will be taken against me if the duty is established. Now, assuming against myself that defences can be pleaded and will be pleaded, the question for the court, in the exercise of its discretion, it's a discretionary question, is the prospect of those defences, does the prospect of those defences mean that it is undesirable to proceed on the 19.8 basis? I'm going to move straight to my submissions on discretion, because I see this as the critical issue. And just addressing that particular point, the first question is the likelihood of individual defences being raised. That's the first question for the court to grapple with. Now, we say that, and that follows from our shipping, that follows from, for example, National Bank of Greece and Althwaite at paragraph 32. Now, we say that the critical defence in this case is one of, and I'll deal with Bambach Europe in 1 second, but the critical defence is going to be disclosure and consent. Well, and that's a defence where it's the defendants who bear the burden of making good that defence. And we say that in circumstances where it's accepted, the service agreements were confidential, couldn't be disclosed save in circumstances to clients, and where it's accepted also there was no policy of disclosure, that the court is entitled to conclude, or at least on a provisional basis, take us at the starting point, that there are unlikely to be a substantial volume of defences involving specific disclosure and specific informed consent.
But as my Lord Justice Nugee put to you earlier, if you're putting your case on bribery, on one view, if everybody in the industry knew that commissions like this, or even a number of people in the class knew that in the industry commissions like this were commonplace, then on the bribery tort, you may fail. But it will depend upon what individual people knew.
Well, assuming that point against me, that point of principle against me.
Well, that's going to be the argument. You see. That's the issue.
And assuming that point against me, it may be that we have as I say, in the list of issues, a question as to whether the duties, tortious and equitable duties, were breached. Now, it may be that in moving from those breaches to relief, it would be desirable to include the fiduciary duty, the breach of equitable duty claims, which were allowed to go forward by the judge. And there's this case management decision as to whether the issue should be streamlined to address the tort of bribery. But we say that that would be an answer, in a sense, that would address that particular concern, because we say that where knowledge is in play, the law establishes, and I would, and maybe for these purposes it's better if I reformulate, or if I focus on the breach of equitable duty, that we say that the burden being on the defendant, that means that those individualised pleadings will have to be raised by the defendant. And the way that the reason why the procedure is desirable is because, first of all, the court can infer that it's very unlikely that allegations of informed consent are going to be pleaded. And that's effectively the conclusion that the judge reached at paragraph 70 of his judgment, that on the evidence before him, there was no, the only specific example where it was said that there was only one specific example given where some disclosure was said to have been made, albeit no detail was given as to what disclosure was made. We say it was therefore the judge's starting point was the right on this discretionary question. And so then the question for the court is, well, is it desirable to start this representative process and then for such individualised offences as may be raised to be raised, with those class members then effectively dropping out of the action going forward to the initial trial to be determined separately? Now that's something that is specifically envisaged, for example, in the case of opt-outs along by Lord Leggett at paragraph 77 of Lloyd and Google. He's very clear that the procedure is a flexible one. But if the court were satisfied that there is a real prospect of a very substantial volume of claims not being subject to any countervailing defence because the defendant is simply not in a position to plead that defence positively, then we say surely it is rhetorically desirable for the cohort, for that, as it were, cohort to go forward and for that issue, the common issue.
Okay, let's say you win.
Yes.
And your common issue is decided. There's a duty, and if there's a payment, there's liability. What happens then?
So at that point, and addressing directly the three suggestions made by my Lord Snowden yesterday, it was suggested there would have to be accommodation made for three separate stages: individual claims and defences, limitation, and quantification. Now, just addressing those, we say that in relation to individual claims, the claimants will be in the same position as the potential individual claimants in Lloyd and Google, who can add individual factors that stand outside of the common issue as to the meaning of the terms. That's something that is available, if required. As to individual defences, we say that, for the reasons I've given, the judge was right to start from the premise that the court cannot be satisfied at this stage that there is going to be an unmanageable number of individual defences.
No, it's not really my question. You haven't got any clients, right? You've only got 2 or 3 clients. So you get a judgment that says what we've just speculated. Then what happens? So you don't get a judgment for anything because we don't know how big the class is. We don't know whether there are individual defences, limitation defences, quantification defences. So what happens practically?
So first of all, we should be in a position readily to discern the class. So in this case, and this is one of the points taken against me, there's not the same plan has been put in place by the claimant in this action as was in Lloyd and Google. But that's because in Lloyd and Google, and as my Lord Master of Rolls will be aware, there was a very critical problem, practical problem at the heart of the class. It wasn't a conceptual problem, it was a practical one. And that was, how do you determine the identity of these estimated 4.4 million Apple users who had a double-click ad cookie downloaded onto their personal device across the relevant period, in a historic period. And what Lord Leggett noted the considerable difficulties at paragraph 152 of his judgment of that process, albeit he was willing to proceed on the basis that they could be surmounted. But in Lloyd and Google, the claimant had to grapple with that ferociously complex factual question in the context of a £3 billion claim. In our case, the class, as in the scale of the litigation, required a very place additional burdens essentially on the claimant to satisfy the court that the class could be identified. In this case, it's a very different scenario. The class members are specific clients where specific commissions were paid under a specific service agreement contract. And indeed, there are accounting provisions in the service agreement contract where CPA will update the LAR as to the commissions paid. So we say that
You'll get disclosure.
in this case, we'll get disclosure. We will know the class, the size of the class, the amount of the commissions immediately. And indeed,
there's a fundamental sort of question lurking here. You can't recover damages on behalf of anybody else other than yourself. Your claim is your own claim for £6,000, and that will be litigated. But unless I'm misunderstanding the whole concept of representative action, you can't recover damages on behalf of anybody else.
That's correct, and there's as Mr. Justice Robin Knowles identified, there may be an ability for remuneration to be extended to the legal representatives and to funders outside of the class fund. That was a suggestion that he was willing to consider, and it's one that in Google.
I don't understand that. Sorry, I don't understand what you just said to me. Sorry.
Oh, so sorry, and I would accept it picks up something that Lord Leggett suggested in his judgment, I believe paragraph 82, as to what happens if a class action succeeds, a representative action 90.8 succeeds, and the extent to which amounts may be distributed to class members, the amount the extent to which.
Yeah, but the problem that my lord is alluding to is the problem that you get a declaration that there is prima facie liability subject to individual defences, limitation and quantification. Anyway, the first two. And so you don't get a judgment for anything. There's no money until the class is identified and they come forward and Mr. Mitchell has an opportunity to say, this one, I told this one and I told that one, and that one's limited.
And just to address that directly, in relation to limitation, that is something that will only affect roughly so 1/3 of the commission payments are not subject.
I completely get your point that there are thousands of clients to whom none of these defences apply, in theory, probably. But I'm asking you practically what is going to occur. So you haven't got the names of these people, you haven't got disclosure of all the commissions paid at the moment. When you get your judgment that says there is liability prima facie subject to individual defences and limitation and consent and so on, what do you do?
And so we say the order we will get is in relation to, let's posit one of the clients who doesn't have, where there's no limitation issue. One has a judgment establishing the duty, establishing the breach, and establishing a right to a money judgment. And we would say
Subject to.
Subject to defences, but with this critical point, that once we have disclosure, and what we are able to identify individual clients who will have an entitlement to a
What are you going to
specific
write
amount.
to them? Dear client, we've got a judgment in your favour. Do you want it? Is that what happens?
And And the way that, one way that was approached in Snowden Google is that what one has a claim pot that is constituted. So the one sees, for example, the commission.
This is my whole point, is that there isn't a pot until you've established that there is no individual defence, no limitation, and the quantification, which you're not going to do on this trial.
And in this case, we say that what it means is, for example, in relation to limitation, 1/3 of the claims approximately will be free of any limitation defence. So that is one proportion of the claim where there's an immediate we would say
claim is it?
Now the claim is brought by CRL, by the respondent, on behalf of the class members, and it's the question then is, well, if we establish the entitlement, those class members will have an immediate to take the example I've given.
But your client is not taken on a sum. Suppose there's an individual, let's call it X Limited, who you can show on the basis of getting all your issues decided in your favour, and there's not being statute barred, and there being no suggestion from the defendant that there's any knowledge or consent. X Limited paid £5,000, sorry, has a claim for £5,000 commission. Whose claim is it? It's X Limited's claim, isn't it? It's not yours. You can't get a judgment in your name for the £5,000, can you?
That's it's entirely correct. The claims are claims of the class members.
So I think what my lord, the Master of Rolls, is asking is, how do you get the cash? How does it work as a matter of procedural mechanics? Are you going to write to X Limited and say there's £5,000 which you can claim if you sign here? What happens? The idea that you can just constitute a pot, the court can't just say, let's create a fund. The court gives, this is a claim.
Well, you could in Google.
In tort.
You see, the point is you could in Google, in theory, have constituted a pot. It could have been said the minimum irreducible data loss is worth £100 per 4 million people. Google must pay £4 billion into the pot. Easy. No defences. There was nothing to say. They'd nick the data without asking, right? Here, they may well have taken advantage of the situation and got secret commissions, but there is nobody to claim it without a defence being established not to exist. So there isn't any money. So what I'm asking, as my lord has correctly analysed, is how you get from a judgment caveated in the way I've said to money. Because otherwise, what's the point in being here? I mean, funders, litigation funders, are not charities, in my estimation anyway. Perhaps it's a contestable point. But they're not charities. They're doing it for money. How do you get to money?
So we say once the entitlement is established, and we say that then there is a possibility of defences, possibility of limitation defences in certain. We accept all of that, but we say that those are matters that are we suggest can in this case be relatively easily traversed, because we don't discern that there will be in fact a large number of defences. It will at the very least, and there are a number of ways in which, having established a starting point, which is that prima facie the appellants are liable for tens of millions of pounds.
So, I mean, let me answer my own question, because I don't think you're really addressing it. The question is, the answer is, you get a list of all the people they paid commissions to, because they must know. You get disclosure of that, specific disclosure of that, if they won't give it to you. And then you write to them all and you say, I've got a judgment. There's unlikely to be any defences for you because X, Y, and Z, because of these are the dates, and because there was no industry knowledge in your case, or whatever it might be. and would you want your money? And in which case we will now go to the second stage and give them a list of all the people that want the money and say, have you got any defences? But how does that work when their defence that they want to run is that industry knowledge and, might be incredibly wide-ranging?
And one, in relation to that, and this is one way in which it can be taken forward, in a sense, if a book build process were undertaken, effectively the sort that my Lord the Master of the Rolls has identified, it would be on the basis of having established a very significant number of common issues that are at that point raised judicata where MNC doesn't have a defence.
No, industry knowledge irrelevant.
And then, so we say we're able to at least and so taking my Lord's example, it was subject to defences. Then, if there is one specific defence that is being suggested, we say that's not a defence to the sort of relief that we're seeking, the sort of breach which we're seeking to establish. But just on my Lord's hypothesis, the process of collecting that class to seek money judgments is enormously facilitated by the fact that the critical issues in the case are raised judicata in their favour.
But just to be very clear here, are you saying that at the end of this process, if you win all the way along the line, that having got disclosure of all the people in respect of whom commissions were paid, all the clients in respect of whom commissions were paid, that you will be recovering on their behalf the entire pot to be distributed pursuant to some scheme or plan that's not in the pleadings, but you will devise, subject presumably to the litigation funder taking a bite out of it first, on behalf of all the representatives. So in effect, you're acting as a collective proceeding in the competition sense. Are you saying that, in other words, all the money, all the profits will be paid to your client for distribution pursuant to some plan or scheme? Or are you saying, no, we'll just take our £6,000, thanks very much. That's all that we've got. And we might, on an ad hoc basis, act as agent for somebody else, one of these other people who would be told, actually, you can, if you want, get some damages out of Marks Clerk, and we'll help you do it. Or is it just that you publicise the fact you've got a judgment and everybody else can just weigh in if they want to and bring individualised proceedings? See, your pleading is a little obscure, if I may put it that way, as to exactly how it's going to work. But picking up what Lord Leggett appears to have just suggested in paragraphs 82 and 83, but very much obiter, and very much recognising in 83 there's a real problem about distribution. It's just actually unclear to me whether you and your litigation funders think that they're going to be picking up a big pot of money on behalf of everybody to be paid to litigation funders and distributed what's left as you would in a true collective proceeding, or whether you're just going to be there with your £6,000 and saying, to everybody else in your class, hey, if you want to, you can go to Marks and Clerk as well. Now, that's a massively different. Those two are massively different in terms, I would suggest, of the practicality of this thing going forward. Because on one view, your litigation funder has access to £6,000 and just the warm, cosy glow that it's done good for everybody. On the other front, you've got effectively a collective proceeding and the litigation funder taking a big chunk of the commissions that would be recoverable by the entire class, which one would have thought might be more attractive to a litigation funder, but it raises all the issues that Lord Leggett flags in paragraph 83. But as to which there's just no answer at the moment. I'm just struggling with that fundamental. I mean, I think we're all just, actually, different questions you've been asked, they're all struggling with that same issue. Just what are you saying happens at the end of the day?
And you've got behind you those very keen to give you a note, even some instructions.
If I may turn my back.
Yes, you may. You may. No, it's not.
So, just looking at the second stage, as it were, of the proceedings, clearly there would be an account of profits type claim advanced, and that raises two possibilities on my Lord Snowden's example. One is the constitution of a pot along the lines that Lord Leggatt identified in 82 and 83, recognising, of course, that there are conceptual debates to be had as to that approach. The other approach is that, having established the class action at the first stage, then of course the funders will be in a strong position and to take forward the second stage, and if that was required to comport and include a book building type process of the sort that my Lord the Master of the Rolls indicated, then clearly there would be a substantial commercial benefit to them doing so. Now, those are two answers, we say, to this question as to what happens to the money.
Because there can't be a pot until you've done the book building.
And it may be of course, in this case, what is unusual is that the identity of the people in the book and the amount of money unusually should be known immediately upon disclosure.
I mean, there is another issue, which is that the identity of the book members is quite unusual in the sense that some of them may be very large companies and some of them may not wish to sue a very large patent attorney, even if there's money in it. But here we are at 12:30. We've got half an hour left. You haven't finished your submissions, I detect, even on discretion, have you?
My Lord, that's correct.
And how much more have you got, bearing in mind that you have a court that's, what should we say, not taken a Trappist vow?
But perhaps if I can take the point just specifically on discretion that are taken against me in the grounds of appeal, I'll take them in a very brief form, just so the court has my submission.
I'm going to give you both the opportunities to put in written responses within a fairly limited period, because I don't think it's going to be practical to get another date. So Mr. Mitchell, be assured of that.
Thank you, my Lord.
Yes, okay. Some quick bullet points. I'd like to give Mr. Mitchell a few minutes orally, if I can.
Of course. And so just very briefly, I've addressed individualised offences. In relation to the class definition, we say that the parameters, that it's something that goes to discretion, that's established by Lord Leggatt, and we say that in this case the constitution of the class is certain, ascertainable, and it's practical. For all the reasons I've given is in contradistinction to some of the points taken against Mr. Lloyd and Lloyd and Google. As to paragraphs 16 to 22 of the grounds of appeal, we say that the various matters set out therein do not surmount the high hurdle needed to set aside the exercise of the first instance judge's discretion. And taking the specific points, it said that the fact that this matter is commercially funded should not be a fact. It tells against or militates against the procedure. We say that's not right. And Lord Leggatt identified at 72 of Lloyd and Google that the fact that the action is commercially funded is a virtue because it imposes, as it were, a discipline on the proceedings. It means it's not a personally motivated claim. The second suggestion is as to the alleged lack of class interest or a failure of Mr. Rouse to entirely explain the position. Now, the critical point taken against me is it suggested that there was a book building exercise that had somehow failed. I won't take the court to the parts of the evidence, but I'll give the note. It seems to be suggested on Mr. Kenrick's second statement at paragraph 54. And in that, he criticised Mr. Rouse for not mentioning that in 2017 he sent a cold call mail shot to certain clients of CPA, suggesting that they had been overcharged. The second criticism made is that, as at the date of the witness statement, M&C had not received client complaints, notwithstanding that Mr. Rouse had posted the fact of the proceedings being issued on his LinkedIn profile. So we suggest that the wider submission made yesterday, that there has somehow been a book build exercise already in this case that has failed, is not made out in the evidence. The second point made or suggested is that M&C's clients are not interested and that it's significant that they are commercial entities and therefore capable of taking a sophisticated or involved decision, I think was the way it was put. Now, that was addressed by Mr. Rouse at paragraph 45 of his first statement, tab 2, page 45 of the supplemental bundle. And there's a debate as to the constitution of M&C's clients. The short point is a large number, should be uncontroversial, are small or medium-sized businesses with IP rights. And that in any event, regardless of the size, it's simply not economically rational, we say, for a client to pursue a bribery claim against a well-resourced firm of attorneys for a few £1,000s. It's just not what you do. On an individual basis. And indeed, that's the point taken against me in relation to Bambach Europe about the fact that its claim is only worth £6,000. And we suggest that the picture will look very different indeed if the common issues we've established, we've identified or established. The next point was about the alleged non-disclosure of funding arrangements, and I'll limit myself simply to saying that on the 30th of June 2023, signature litigation did write Clifford Chance to confirm the funder's ongoing commitment to the case, but I'm not sure there's a great deal to be extracted from that. And then in the final point I make is this, that one of the final objections raised by my learned friend is that is to express concern about potential waste of court resources. And of course, we're anxious to avoid that. But we also say that in circumstances where, on our case, the appellants have received tens of millions of pounds of secret commissions, paid directly or indirectly out of their own clients' funds, there is a strong public interest in having that question determined. And in that respect, I won't take the court there, but the words of Lord Justice Romer in the Hovenden case, which is cited at paragraph 42 of Wood, are apposite, that the courts of law of this country have always strongly condemned, and where they could, punished the bribing of agents.
You mentioned 10, I don't want to delay you, but is there a reference to the quantification of your claim there? You said tens of millions of pounds of the commissions. I mean, is there a reference somewhere to, has anybody even put a finger in the air at this?
I believe that's the expectation set out in the evidence of Mr. Rouse. I don't understand that it's controverted. I can find the exact reference. I understand, but I'll be corrected that that's something that's been in common ground since before the
Well, that can go in your written, final written submissions. Anything else orally?
Unless I can assist further.
No.
Is the response of the submissions.
Well, thank you very much, Mr. Leslie. Mr. Mitchell, conscious as we are that you both will have the opportunity to put in written submissions, I think that they should be limited to 10 pages, please, and they should come in by Monday at 4 p.m, please. But that will give you an an opportunity to take a deep breath after this hearing and look at the transcript. So I leave it to you with that in mind.
I'm grateful, my
Make
lord, and
best use of your 23 minutes.
I will, my lord, and I hope that my written submissions may be more structured and elegant than what I say in response to the various points that my learned friend has raised. But there are, I think, some fundamental points that it's worth me just dwelling on orally, if I may. The first, I think, is the question about the sort of precise procedural nature of this appeal. And as your lordships saw earlier, the appeal is against the refusal of the judge to make an order under 1982, and that would have been an order that the representative part of the claim is dismissed in effect. So that's the appeal, and that gives rise to the question we would suggest as to whether there is any common issue which has been identified by my learned friend's side that is both capable in the technical sense of being pursued on a common basis and where the court decides that it is an issue that should go forward. I accept that if this court decides that there is an issue that can and should go forward on a representative basis, then the appeal fails. But, of course, even in the absence of a respondent's notice, if this court decides that the only issue that can go forward on a representative basis is one narrower than the procedural steps taken in the case so far have identified, then your lordships will say that on the face of the judgment or judgments, and that will be of benefit to the parties going forward.
And the poor old judge.
And the poor old judge, my lord, yes. Now, in our respectful submission, there are really two different points that have been in play in substance here. The first is my learned friend's suggestion, his primary position, which is you can decide now, this court can decide now, that liability and breach can be determined on a common basis across the whole class, sort of full stop, as it were, or at least subject to limitation. That's the case he seeks to advance. It is not, of course, the same as the proposal made by my Lord Justice Snowden, or not proposal, a suggestion made in argument yesterday by my Lord Justice Snowden. That's a much narrower issue. We need to be clear that there are two levels to this debate. There's the higher level that my learned friend suggests, and there is what maybe I'm ill-elegantly calling the lower level that my Lord Justice Snowden suggested. So the first point for this court to decide is whether it can safely decide now that liability and breach can be determined, what I may pejoratively call in the abstract. That is, determined and necessarily determined on behalf of every member of the class by reference only to the terms of business and the fact that those members of the class contracted on those terms.
Without him to interrupt, you keep saying liability and breach. Do you mean duty and breach?
Sorry, my lord. Duty and breach. Yes, duty and breach. So what my learned friend is doing is inviting you to decide now that duty and breach can be determined for every member of the class, what I would describe as in the abstract.
And you say it can't.
And we say it can't. I'll come back and pick up a few points about that in a moment. That's the key first issue. If the court is against my learned friend on that, then the only other, if I may say so, show in town is the narrower suggestion made by my Lord Justice Snowden yesterday, which is a determination of the meaning of the terms of business and a determination of in a sense, a prima facie finding that those terms of business give rise to the necessary duty.
And just to be clear for the transcript, that's a trimmed down version of questions 14 and 15, as my Lord the Master of the Rolls perhaps suggested, subject to defences.
Yes, But subject to defences, one needs to be very clear what that means. Of course, defence may be defence in the technical sense of something which a defendant must raise in response to a prima facie cause of action established by a claimant. But of course, defence in a more colloquial sense is the response of the defendant to the allegations that constitute the cause of action. So if in a contract case, if the defendant says no contract was formed, it's for the plaintiff to establish that the contract was formed. The defendant may defend that by saying, well, I didn't meet the relevant person, there was no contract. That's when we're talking about defences, we must be talking, we would suggest, about defence in both senses. And I think that that's inherent in what my Lord Justice Snowden said yesterday, because the sort of reservation included any matters that arose from the individual circumstances of particular clients.
Well, except the class deals with many of those fundamental questions. So, for example, no contract, you're not in the class.
Indeed, my Lord.
Can we try and identify what you say on Lord Justice Snowden's issue? The defences that would remain to be in issue can be. One of them is obviously limitation, which is a true defence. One of them is informed consent, which is on any view accepted to be a defence. What else?
Well, there's the broader question about whether there was a duty and whether that duty was breached, given the actual circumstances in which the retainer took place. So, in the light of the
that's the Bambach point.
Let's call it the Bambach point. So,
given what you were instructed to do, there was no breach,
and potentially for other people what they knew and how and what reliance they placed. All of that goes to. It's not a defence in a limitation sense. It's just a response to the claim.
It's an individualised response to the claim.
It is, my Lord. I'm grateful for that phrase. That is a matter which, on my Lord's proposal yesterday, or suggestion yesterday, would be reserved for stage 2.
But actually, it would completely negate the purpose of doing stage 1.
Well,
that's your argument.
And that's our point on discretion. That even if theoretically the court is entitled to sever liability into parts, you're not really resolving anything meaningful.
Do you accept that there are many, using that word indulgently for a moment, there are many clients who could have no defence? In other words, they didn't have any individualised communication about this at all. You simply referred them to CPA in the usual way, CPA paid you a commission, they have no limitation point, they couldn't say anything about informed consent. So do you accept that even though, of course, there will be some who could raise that, there will have been quite a lot of plain vanilla activity envisaged by the contractual terms themselves?
I'm not sure I can give a proper response to that, my Lord. There's nothing in the evidence that casts any light on that.
But it sort of stands to reason.
Well, I mean,
because otherwise, why would you have put it in standard terms and conditions that this is what you're going to do?
Well, but that's not to say that there weren't a number of situations in which there was individualised discussion.
Well, when I say you, I mean I'm doing this collectively because for reasons which are not explained, there's this separate little partnership off on the side. Your clients agreed that they wouldn't disclose the existence of the fees agreement to anybody except in limited circumstances, and they put in place standard terms to apply to all their clients. I mean, doesn't it actually stand to reason, as my Lord has just put to you, that there will be many, many plain vanilla people who just were never told of the commissions and were dealt with entirely as your standard terms of business provided?
Well, just again on the confidentiality point, my Lord, I made the point yesterday that it's subject to.
Yeah, I know. Well, I put that reservation into my question.
Thank you, my Lord. I don't think I can rebut the suggestion that there will be many, many in that category. Whether that many, many means, let's just assume there's 3,000 clients. Whether many, many means 500 vanilla or 2,500 vanilla or higher, there's nothing in the evidence that can.
You can't go beyond the evidence.
No, and one of the particular reasons, well, of course, I'm not allowed to go beyond the evidence, but there's a particular reason why one has to be very cautious about this, which is that knowledge on our case is relevant not just to informed consent, but
your case is that industry-wide knowledge was such that the suggestion that these were really secret is pie in the sky. And not everybody, but a very large number of
maybe
people knew what was likely to be going on, and that's enough.
Well, there's 2 points there. That's that general point, my lord, yes, but also then specifically, if a specific client comes forward and to us and to pursue a claim, we can say, well, actually, you instructed X and Co overseas. They knew all about this. We're going to effectively put you to proof that you didn't know. And knowledge goes not just to informed consent, but knowledge goes, at least on our argument, to whether trust and confidence was reposed in M&C on this particular point. So that if a client knew full well from its knowledge of the industry that CMF was paid, that goes to whether actually it really did repose trust and confidence in M&C in respect to the fact there's a reference to CPA in the terms of business. Now, we may or may not be right about that as an argument both on the facts and the law, but that's something which we would wish to articulate as a response to any claim made by a particular client. But can I then, I think that takes me next to what stage 1 and stage 2, 3, 4 really means here, because I think there appears to be a disconnect between what my learned friend Mr. Leslie anticipates and what my Lord Justice Snowden anticipated in the suggestion made yesterday afternoon. Mr. Leslie seems to think that you have stage 1 and that the representative is still a representative thereafter. But the premise of my Lord's suggestion is the contrary. My Lord's suggestion is to identify a common issue that can go ahead under 19.8, which is the terms of business point, but that necessarily presupposes that nothing beyond that is in fact capable of being determined on a common basis. Defences in both senses of the word, limitation so far as it affects the class.
Or may, it may or may not. You only go so far as you can currently see that there is an issue which you can see, you determine it, and then you take stock and say, well, now having determined that in light of that judgment, is there another issue or not?
But in deciding, and I would accept this goes more to discretion than a sort of threshold point, but in deciding whether this should be allowed to go forward, the court can take a view now about whether it's actually realistic for Mr. Leslie's side to say that there are aspects of the case that can be pursued on a representative basis at stages 2,
well, why
etc.
can't Mr. Leslie say, you have just accepted that there are many, many plain vanilla clients, and there is, if he wins, the Lord Justice Snowden point, if we can put it that way at stage 1, there is nothing more to say. You must pay.
Well,
and so stage 2 may be very interesting for the non-plain vanilla clients, but may never happen.
Well, but my lord, then that ties in specifically with what I was about to say, that once you get beyond stage 1, what is required is for a client to come forward and say, I want to make a claim.
Yes.
I want to make a claim.
That's what I was trying to get Mr.
Well, quite,
Leslie to
because
say.
This is not a statutory class process. It is a process which is built upon the basic building blocks of English and Welsh procedural law, namely that if you have a cause of action you want the court to give a judgment about, you come forward and advance your claim and ask for a judgment in your favour.
Except Legate seems in paragraphs 82 and 83 to envisage something much broader.
Well, that was obiter. That relates to that case. What we are concerned with here, on any footing, is a series of separate clients with separate causes of action arising from separate contracts. Each has a cause of action, and if they make that cause of action good, then they are ultimately entitled to a money judgment. But what we suggest is that once you get beyond stage one, then the fact that there are these non-common matters that will have to be adjudicated upon, in a sense, in any case, I mean, the client has to come forward, and then we have to have our opportunity to say, okay, we do or do not accept your vanilla. They have to come forward and put their case to us. You can't just throw out the procedural burdens that lie on claimants in this situation. At stage two,
That's the point I was putting to Mr. Leslie.
Yes.
That you have to have the opportunity. But let's assume there are many, many plain vanilla clients for whom there is nothing you can say. You have to look through the list and say, oh, well, I agree, I can't say anything by way of defence in relation to these clients, so I'd better cough up.
Well, my lord, that with respect misses a step. The first step is, and let's assume without me conceding on my feet now, that a disclosure order could be made to identify what we consider to be the people within the class.
I thought you were going to make that point.
And I'm not, but I haven't got instructions to make that concession, but assume against me that such an order could be made. The representative would then have that information, names and addresses. It can then do what's colloquially called the book build. It can approach people. Nothing further happens at that point until particular clients come forward by whatever process there is, form filling or whatever it might be.
Okay, but is that right? The hypothesis here is that there will be within the list of people that you have and give disclosure of, a large number of plain vanilla clients of yours who were beneficiaries to whom you owed a duty. There were people to whom you owed a duty which you breached. It may have been fiduciary, it may be that you were in receipt of bribes. Well, you have the liability to account, don't you? I mean,
no, my lord. On your proposal, with respect, there's been a partial determination. The burden then still lies on. This is why we say that the idea with respect is inappropriate, because nothing actually will be determined. There will just be a sort of prima facie determination of what the position would be, looking only at the terms of business.
Well, you are holding. I mean, let's get a bit technical about this, Mr. Mitchell. In theory, you are holding your client's money if they succeed. So
but they won't have succeeded, my lord. That's the point. They were at stage one. They won't have succeeded. The burden is still on them to come forward and advance a claim.
Irrespective of any establishment of the right. I mean, if the position is that you took the money in the way that they allege, then you are holding their money.
But there's the if there, my lord, isn't it? I mean, it's if. But the burden is on any particular client to establish its case. So, let me just follow through. Well, my lord, that must, in our respectful submission, that must be right, because liability won't have been determined. There will just be a sort of prima facie determination.
This is where it all gets a bit unattractive. If you say, I may be holding a large sum of money, millions of pounds, on trust for other people, having taken it as a bribe or in breach of fiduciary duty, but you can't have it back because you've got the burden of proof on showing it's theirs.
Well, my lord, with respect, that's just a consequence of the fact that if a person wishes to advance a claim, then the burden is on them to come forward and advance the claim.
All right.
What there would be is the list. The book building exercise can take place, and then if clients wish to pursue individual claims, then they can come forward and do that. And it's in response to that that we then have our opportunity to decide whether we treat them as a vanilla client against whom we would, on this hypothesis, have no defence, or whether we wish to advance particular matters in respect of those clients. But that will be in circumstances where particular people have come forward, and then my clients and those they instruct can interrogate memories and documents to look at whether there is a defence to be articulated against a particular person. But
So what's
that
wrong with
tracks the normal process.
So what's wrong with that?
But that's not what Mr. Leslie's envisaging. What he's envisaging is that there would be some sort of open-ended, well, here's a list of thousands of clients. Ball's in your court, M&C now. We're not going to book build at this stage. We're just going to see whether you want to say you can advance defences against particular people out of the thousands. And that's, we would say, is fundamentally wrong.
Am I wrong in thinking that if a fiduciary accepts a bribe, he falls as a matter of law under a liability to account and to hold the monies on trust long before the court, if he disputes it, declares it to be so? I mean, isn't it the nature of fiduciary, assuming against you that you lose on the questions of the existence of the duty and the conflict, and it's not disputed that you received the money, why isn't the boot on your foot to say, actually, I don't hold the money for this beneficiary because, in fact, they knew, or et cetera, et cetera, et cetera? Surely you're a delinquent fiduciary in those circumstances.
But that begs the question, with respect, my lord. Your lordship's right that if a fiduciary duty is established or admitted, then I accept that one of the consequences is that the bribes may be held on trust for the principal or liability to account. But that's because the existence of the fiduciary relationship has been established or admitted.
Well, Mr. Mitchell, what Mr. Leslie wants is to persuade a judge that on proof that somebody signed a contract containing your terms and conditions, all that needs to be done to establish liability is proof of payment subject to fully informed consent and limitation. That was how he presented it to us. Now, you're not asking us to decide he's wrong about that. He's not asking us to decide he's right about that. But if he is right about that, then it does follow that subject to asserting fully informed consent or limitation in any particular case, in other words, this was industry knowledge, argument doesn't work because that's already been decided that it doesn't work, then the consequences that my lord said do rather follow. Your point is, but we do have a defence, or we may have a defence in certain cases that everybody knew this was what was going on, and that qualifies the duty, and therefore the argument that Mr. Leslie wants to put forward fails. Well, so be it. He accepted that it might fail, but if it succeeded, then there is value.
But the court
that way, isn't there?
But the court won't, on, as I understand my lord's proposal, keep saying proposal, a suggestion, is that point won't be resolved at a first stage. The court's only going to be looking at the terms of business and saying what duties arise from that. The court at that first trial won't be saying that we are wrong to put forward defences on an individual basis based on circumstances.
I think there's a little bit of a misunderstanding in what everybody is saying. There cannot be a sensible determination of the issue that Mr. Leslie proposes without dealing with your proposed generic defence, because your generic defence means that there is no claim by anyone because everyone in the industry knew what was going on, and therefore that does have to be determined in order to determine the issues 13 and 14.
I think,
unfortunately, nobody has formulated that issue at the moment.
well, my lord, I'm sorry, there is probably misunderstanding at various levels here. We do run a generic defence based upon the reading of the terms of business, and it's a point my Lord Justice Snowden pointed out yesterday. That point will obviously be resolved at stage one, if stage one's allowed to happen. We don't, as I remember our pleading, say that the fact of industry knowledge gives us a generic defence to everybody.
No, your whole point is...
that has to be examined individually.
Well, that's your
And
point. That's why you say it's not suitable for collective
That's right.
determination.
But we won't know, sorry to interrupt, my lord, but we won't know at the end of stage one whether, the court won't have decided at the end of stage one whether our contentions about our ability to run individual defences is a good or bad point, whether as a matter of law
I think
or
what
fact.
my lord has just said, and as I understood Mr. Leslie, a claimant's case is that it's no defence to say that people in the industry knew this was going on.
Yeah.
The only defence is fully informed consent, which means that you need to have actually told them. Now, as I say, we're not going to say whether that's right or wrong, but that is the case he wants to run. And I think he accepted it. If he doesn't get home on that, then he's got a problem. But if he does get home on that, then I think it's you who have a problem.
And I know we're overrunning, and I can deal with some of this in writing. But the point, if we just come back and use Bam Batch as an example, as I understand the suggestion, the first trial won't determine whether our defence to the Bam Batch claim is well founded or not.
Well, that depends.
I think Mr. Leslie thinks he will.
Yes, it will.
He will determine.
Because the issues seem to want to try out the Bam Batch case.
But no one's anticipating, certainly my learned friend, well, no, we were at the MC in July, but my learned friend's side is suggesting there should be no question of disclosure of the Bam Batch specific documents that go to the formation of the relationship between Bam Batch and M&C or Bam Batch and CPA.
Okay, we need to know that in your reply, because I'm, for one, thought the issues that the judge thought he was trying did include the Bam Batch specific issues.
No,
Okay.
no, and I will point that it's specifically said in the covering letter where the draft list of issues was sent to the court, and in my learned friend's written submissions, that it was to be tried by reference to the terms of business only, and therefore not including any question of Bam Batch specific circumstances.
So, I mean, where we are is that my lord has very helpfully said, and Mr. Leslie has not jumped up to say that he's wrong, and I see him nodding his head, that what he wants is a trial of a generic issue on the simple question of the meaning of the terms and conditions, and the question of whether, if a payment is made of a commission in respect of somebody who signed those terms and conditions, subject to limitation and fully informed consent being proved, there is liability. And that would therefore mean that you could say, no, that is not the case. There are all sorts of other defences I could raise of half-secret payments, blah, blah, blah. And that would be determined against you or for you. If for you, the case would end, and if against you, it wouldn't. Now, subject to that, that at least is a little bit of clarity as to what they want. I'm concerned about the issues, and in your written submissions on both sides, I think it would be useful if there was some drafting. I'm looking at my lords to see if they agree, of what issues you may say, I think your answer is there aren't any that are sensibly determinable, but for Mr. Leslie, he should, if he says there are issues that are sensible, he should draft them so we can see what they are. And it would be useful if both of you have any second thoughts about the issues that the judge has determined in that list, because I, for one, have some doubt about the breach issues, which seem to me to be rather more, what should we say, specific than they should be, but I don't know what your submissions will be. But subject to that, I think we've probably got in our heads the things that we have to decide, and it's pretty clear we are not going to decide who's right. We are only going to decide whether the 19.8 application ought to have succeeded. And if you're right that there is no useful purpose in determining even that generic issue for the reason you've just given, then you'll succeed. And if he's right that there is a useful purpose, then subject to discretion, he'll succeed. But of course, you have to get over the judge's interference with the judge's discretion, which was alluded to for about 30 seconds in the course of a day and a half's argument. But it does seem quite important as well. Now, is that a reasonable place to leave oral submissions?
Yes, my lord.
Yes. I mean, I'm sorry we've had such a frenetic day and a half, but it's a difficult case, and I don't want either of you or anybody behind you to be unhappy that we've left it. It's open to you to say no. You must make another day for further oral argument. I'm not encouraging you to, because it'll be a little while ahead if you did, but I'm just saying that do you want to or not?
For our part, we don't.
No, my lord, I suppose both sides may reserve the right to come back depending on how things develop in the written submission.
Well, you might reserve the right to put in replies to the written submissions, and for my part, I wouldn't be hostile to that, provided if the replies to the written submissions came in by Wednesday at 4 o'clock. I've said 10 pages. I'm not going to hold you precisely to that because you may want to append appendices, but short, please. Don't go to ridiculous length. And you all have liberty to apply because it's been a complicated case.
Thank you,
Subject
my lord.
to that, then, we will now reserve our judgments.
I have one other point. Without telling you what to do, if either side wishes to make any submissions on what Lord Leggett said at paragraph 83 about how you go about creating a pot, or whether you can create a pot, then it might be helpful if you were going to address that issue to provide us, if possible, with a copy of Professor Mulheron's article, which he there refers to, which seems to touch on the issue in a way he alludes to but doesn't explain.
I mean, that obviously I'm not going to say we won't do that, my lord, but that does open up an entirely new
Pot
area.
of worms.
Indeed.
Yes, but it was one of the points on which you relied in saying, as a matter of discretion, this is not a helpful procedure because it runs into the sand. So, to the extent that that's a point you rely on.
Understood, my lord.
Yes.
And I think the Independiente is in the bundle at tab 6.
Yes.
Good. Thank you both. Thanks to all behind you, juniors and solicitors, and indeed clients. I think this has been a difficult and interesting case. We're grateful for the oral arguments. We'll take time in the usual way. When we hand down our judgments, will you please agree costs and an order if you can, and make sure that you do not use our judgment in draft for any other purpose of any kind or circulate it beyond the immediate representatives in the case. And we will deal with supplementals in writing.
Thank you, my
very
lord.
much.
For eyes.